We provide this seminar every year, and what we do over the course of the year is keep track of developments in the area of construction law. We try to put this on in the winter when things at times can be a little slower for the construction industry. The risk of doing that, obviously, is for the second year in a row we've had a snow delay, so appreciate all of you hanging with us and attending today. The first area that we wanted to focus on is areas in recent developments in the areas of mechanics lien law. The biggest case that came down in this area was actually decided by the Pennsylvania Supreme Court. It's the Bricklayers of Western PA Combined Funds, which is one of the union trust funds, versus Scott's Development Company. Scott's Development Company was the developer of a particular project. The general contractor on this project had signed a collective bargaining agreement with two trade unions to use union trades on the construction project. Now, under that collective bargaining agreement, the general contractor obviously was required to make contributions to union benefits funds. Now, for the project at issue, the general contractor used the union workers under the collective bargaining agreement, but failed to make the contributions. Now, the trustees of the union funds thereafter filed a mechanics lien claim on behalf of the unions for the unpaid contributions. In a very surprising decision, the Superior Court, which is the intermediate appellate court, so you have a trial court, and the trial court did what I think most people expected, most construction lawyers expected to happen, was they dismissed the lien claim. And they said a union trust fund doesn't have the right to file a mechanics lien claim for unpaid dues. The Superior Court, however, in a surprising decision, reversed that and said that union trust funds have mechanics lien rights as a subcontractor under the lien law. And one of the things that was most interesting about that Superior Court decision was that the Superior Court held that there should be a liberal construction of the lien law because of the lien law's remedial purpose. Now, eventually, the Supreme Court decided to hear the case. They issued their decision just about a year ago, last April. And the question presented was, do the union trust funds or their members fall within the definition of subcontractor under the lien law? It's a pretty lengthy opinion, several points that are worthy of discussion. In analyzing the issues in the case, the court indicated that the plain language of the lien law was not clear on whether union members performing work for a project could be considered a subcontractor. So the court therefore looked at these four different factors in evaluating this issue. First, they looked at the, quote, most natural meaning of the word subcontractor and said that subcontractor simply does not denote employees of a contractor, because really that's the issue here. These were the direct employees of the contractor that was performing the work, and the court has to evaluate, do those employees fall under the definition of subcontractor? And under the plain meaning, and actually the court did things like look at dictionary definitions of subcontractor, look at how that term has been applied through cases, and determined that the most natural meaning of that word would not include employees of a contractor. The court also considered that at the time the 1963 lien law was passed, the Pennsylvania Constitution prohibited statutes from authorizing the extension of liens. Now, the trustees were arguing against that by saying that that specific provision from prior to 1963 was repealed in the 1968 Constitution amendments, so that that prohibition should not be used to deny protection of the lien law to those union workers. The court also looked at the official comment to Section 2015, which is the definition of subcontractor. And under that official comment, and the comments are something that the legislature adopts when a statute is passed. They're actually not part of the law itself, but they are commentary that can provide insight. And the comments to this section says that laborers are not subcontractors, even though employed by a contractor. Obviously, that's a pretty compelling point in terms of whether the legislature intended union workers to be covered as subcontractors. And then, perhaps most importantly, on more of a policy basis, In this last point, the court noted that including employees or their unions or union trust funds in the definition of subcontractor would in essence make a property owner a guarantor of the general contractor's employment obligations and create an entirely new class of subcontractors. And in that regard, it's important to note that you're not talking in this case about denying the union trust fund a right to legal recourse. In other words, that union trust fund is certainly free to go and sue the general contractor. The problem, as you might imagine, is the practical one of not being able to get blood from a stone. If that general contractor doesn't have the funds to pay to begin with, going and getting a judgment against them isn't necessarily going to put the trust funds in any better position to recoup the monies that were owed. That's why the Union Trust Fund was trying to come up with this creative way of filing a mechanics lien to actually have something that they could collect against, because the mechanics lien claim is a claim against the real property. However, the court said it would be basically inequitable and on a policy basis inappropriate to make property owners the guarantors of the general contractor's obligations. Therefore, the court ultimately concluded that it would not endorse such a dramatic shift in the interpretation of the lien law without the legislature's clearly evidencing such an intent. The court also considered, after going through that analysis, whether the trustees had lien rights under an implied in fact theory, and ruled that the theory was not pled and therefore should not have been considered by the Superior Court. But more importantly, even if the court would have considered it, the Supreme Court said that an implied in fact contract did not exist because the collective bargaining agreement at the time it was entered into didn't contemplate the specific work at issue on the specific project involved in this case. So for all of those reasons, the court held that the Union Trust Fund did not have lien rights. That really left the other significant point from the Superior Court's decision was that the Superior Court said that there is to be this liberal interpretation of the lien law. And that was a pretty dramatic shift, because there are a lot of cases in Pennsylvania historically that say that the lien law, because of the extreme rights that it presents to contractors, must be strictly construed. The Superior Court said, well, because of the Statutory Construction Act, that act indicates that if a statute is intended to provide a remedial relief to someone, and if it's supposed to provide a remedy, that remedy, the effect of that should be liberally construed. Now, the Supreme Court, surprisingly, did not address that issue at all. So we're left with the Superior Court saying the act should be liberally construed, and then the Supreme Court's silence on the issue. So what that does is it allows lawyers to argue both ways depending upon the case. And until the Supreme Court addresses this issue, we really don't know whether courts are going to liberally apply the statute or strictly construe it in accordance with the historic law. So that's certainly the biggest case law development in mechanics lien law. A couple significant amendments. The first one I'll go through pretty quickly because it is really limited more to residential issues. This amendment was signed into law on July 9th of this past year, and it's intended to protect homeowners from mechanics liens claims of subcontractors when the homeowner has paid the general contractor in full for work performed on the owner's personal residence. Prior to this amendment, that would not have been a defense to a lien claim from a subcontractor. In addition, the amendments clarified the priority rights of open-ended mortgages in response to a Superior Court decision from 2012, and we'll touch on that in a moment. Now, here are the lien rights of a subcontractor for work on residential property. And as you can see from the language, the subcontractor will not have lien rights if the owner or the tenant paid the full contract price to the contractor and the property is used as the residence by the owner, and then you have the definition of what a residential property is. That's an issue that, frankly, the legislature struggled with over the years, but you can see the current definition. Now, the owner of a residential property may file a motion to have a mechanics lien stricken or discharged if it can be shown that the owner or tenant paid the full contract price. If they didn't pay the full contract price, the lien will be limited to the amount, the balance remaining, the unpaid balance remaining on that contract. Then in terms of the lien priority, this was really lobbied for pretty heavily by banks. In this Commerce Bank decision, the Superior Court held that unless all of the proceeds of a mortgage were used to pay for actual construction costs, basically hard costs, not soft costs, not financing, not brokerage fees, not any of the soft costs associated with a construction deal involving the purchase of real estate. Unless all of the proceeds were used for hard costs, the bank would not be entitled to the super priority that's provided for in the mechanics lien law. As I said, banks lobbied hard against that decision and were successful in getting this amendment passed, which indicates now that as long as 60% of the proceeds of the mortgage are intended to pay for or used to pay for the cost of construction, then the bank will be entitled to this super priority, which basically, priority is a significant issue because if you file a mechanics lien on a project, if there is an open-ended mortgage, the bank is going to be in front of you if the project goes bad and there's a foreclosure action to force the sale of the property. Now, in terms of the definition of cost of construction, it's a lengthy one. It's set forth in this slide. I won't read it for you. The bottom line is that soft costs are now included in the definition of construction costs. So what the Superior Court previously said would not entitle a bank to use this super priority has been overruled, and banks now get the super priority regardless of whether the proceeds of the mortgage are used for these soft costs. Now, that amendment, as I indicated, largely related to residential property. This next amendment that was signed into law on October 14th, 2014, is really a very fundamental change to the mechanics lien law on commercial projects throughout the Commonwealth. It establishes a structured notice procedure. If any of you do work in Ohio, the process that is now being implemented in Pennsylvania will be very similar to the process that has been used in Ohio for years, with a notice of commencement and a notice of furnishing that we'll review here momentarily. Now, these amendments were actually supported both by owners and general contractors in an effort to provide them with a better method to identify all subcontractors and material suppliers with lien rights on a project. And in that regard, for those longtime attendees of this seminar, you'll recall when the lien law was significantly amended several years ago to add second-tier subcontractors to the list of potential lien claimants, one of the issues that we identified as soon as those amendments were passed were that both general contractors and owners are now faced with potential lien claims from entities that they didn't even know were working on their project. And the problem is, if you're a second-tier sub, unless that subcontractor discloses that entity to you, you've got no way of knowing that they're performing work on your project. All of a sudden, if that first-tier sub's in financial trouble, doesn't pay that second-tier sub, you could have a lien filed on your project from an entity that you didn't even know was performing work. So these amendments address that problem that we identified and indicate now that unless that second-tier sub files a notice of furnishing, they will not have lien rights. So we'll get to that in a minute. The first significant update is the requirement that the Commonwealth, and specifically the Pennsylvania Department of General Services, has to create an internet-based directory called a construction notices directory. That directory has to be operational by December 31 or sooner. And if the department designates an operational date prior to December 31, 2016, it will be published at least 90 days in advance of the operational date. I looked for an update on this last night, and there is none. With the statute just being passed in October, there's been no, at least published, progress on the creation of this directory. But it certainly makes a lot of sense that it will be internet-based, so you're not going to have to worry about, having someone go to the prothonotary or clerk's office in each county where a project's being conducted. You'll be able to do all of this online. The new notice requirements apply only to a searchable project, which is defined as a project consisting of the construction, alteration, or repair of an improvement costing at least $1.5 million. So it's obviously not a very high threshold for a new construction project. The Act does not specifically state whether the soft costs that we were referring to earlier will be included in determining whether that $1.5 million threshold is met. But obviously it's not a very high threshold for a construction project. Now, the 4 new types of notices that you're going to hear about once this directory is created are the notice of commencement, the notice of furnishing, notice of completion, and notice of non-payment. All of those notices, when they're submitted to the directory, they must contain the county in which the project is located, the tax ID number of each parcel included in the project property, and the building permit number for the project. Now, the first of those is the notice of commencement. The notice of commencement, exactly as it sounds, is a document that would be filed by the project owner or an agent of the owner, and it must be filed before any work, labor, or materials are furnished for a particular project. And the notice of commencement is an announcement by the owner to the world saying, hey, here I am, I'm commencing a construction project. This is my notice of commencement. Now, for contractors in the room, the notice of commencement is a responsibility that can be delegated by an owner to a contractor. So for those contractors in the room, I think you can expect to see in your contracts, once this directory is created, an obligation to file this notice of commencement on behalf of the owner. And the statute specifically contemplates that a contractor may serve as an agent of the owner for purposes of filing the notice of commencement if it's specifically authorized by contract and the owner assumes responsibility for the contractor's actions with respect to that filing. Now, here's what the notice of commencement must contain. It's the full name, address, and email address of the contractor, the name and location of the project, including the county where the project is located, that legal description, the information regarding the owner, the name and contact information of a surety for any performance or payment bonds. So, while at times those of you in the room that are subcontractors have struggled to get payment bond information, now it will be available online whenever a bond is available for a project for which a lien waiver is sought. And we'll talk about those lien waivers in a minute. And also the unique identifying number that is assigned to the notice of commencement. And that will be assigned through the web-based directory. In addition to filing the notice online, got to also do the old school way and post it on the project site in a conspicuous space, and it's got to remain up throughout the course of the project. And again, the idea here is to identify, to everyone that may be performing work on the project, that if you want to preserve your lien rights, you've got to file your notice of furnishing prior to performing any work. Now, just like the notice of commencement made sense in terms of its name, the notice of furnishing also makes sense. That is basically an announcement from a contractor or a supplier that I am performing work or supplying goods on this project. I'm furnishing something to the project, and I am therefore filing this notice so that I preserve my lien rights. And if that notice of furnishing is not filed online within 45 days after first performing work or delivering materials at the project site, you will lose your lien rights. And again, that's not to say that you're denied any legal remedy. You could always pursue a breach of contract claim if you're not paid, but you wouldn't have your mechanics lien rights. Mechanics lien rights are very powerful rights for anyone that is not paid. One of the biggest reasons is because of the mortgages that we talked about earlier. Almost every project has a mortgage. Almost every mortgage has a requirement that the owner keep the project free and clear from any encumbrances on title. So if there's a mechanics lien claim filed, that would be a violation of the mortgage on the project. The bank is going to say, you've got to get this cleaned up. The bank's going to say that to the owner. The owner, in turn, is going to look at its general contract with the general contractor and say, in all likelihood, you're obligated under your contract to keep my project free and clear from any encumbrances on title. So you need to get this lien cleaned up. The general contractor then is likely going to be the entity that's going to have to deal with that lien claim. So what needs to be included in that notice of furnishing? Here are the 4 elements right here. A general description of the labor or materials being furnished, the full name and address of the company supplying the labor and materials, the full name and address of the person that it contracted for, and a description of the project sufficient to identify it based on the description set forth in the notice of commencement. Now, the Act expressly states that a subcontractor's failure to substantially comply with these requirements results in the forfeiture of the right to file a lien claim. So again, this is important for any subcontractor providing labor and materials to file this. The benefit to both the owner and the general contractor is now you're going to know who's performing work on your project. Therefore, you can ensure that these entities are getting paid and protect yourself against the risk of having to pay twice for the same work. Now, a notice of completion is permitted but not required. It allows an owner to file a notice of completion within 45 days of the actual completion, and the definition of actual completion is set forth here. Upon filing, this notice is transmitted through the directory to all of the subs who submitted a notice of furnishing. So basically the way this is working is if you file a notice of furnishing, when the owner completes the project, if the owner files this notice of completion, as a sub, you would get notice of that, and you're now going to know your clock's ticking in terms of your lien rights. Now, subs are permitted to file a notice of non-payment, but again, this is a notice, unlike the first 2, this notice is permitted but not required. You don't have to file this to file your lien rights. Certainly, our recommendation is going to be, if you haven't been paid, you should file this notice. Because again, you know, as a sub who maybe has not been paid on a project, you need to understand, obviously, no one wants to pay for the same work twice. So the earlier you can get out in front of that and indicate that you have not been paid for work that you've performed, the greater the likelihood is that the general contractor and the owner are going to be able to mitigate against the risk of paying twice, make sure that you get paid without them facing the possibility, again, of paying twice for the same work. Now, in terms of blanket lien waivers, which again, as a reminder, under Pennsylvania law today, the only time at which you can file a blanket lien waiver, and that's a lien waiver that is filed up front before the start of a project, which waives the rights of all subcontractors to file liens on a project. Those are permitted in Pennsylvania still, but they're only permitted if there is a payment bond for the full amount of the project that has been posted. Nothing in the amendments prohibit the use of blanket lien waivers if a payment bond has been posted. Again, that payment bond would have to be set forth in the notice of commencement, and that would eliminate the rights of those subs to pursue lien claims, but obviously they would have the right to pursue a claim on that payment bond if they have not been paid. Now, thinking ahead, the legislature had a couple interesting provisions, and I actually think this probably relates to the Contractor and Subcontractor Payment Act. When that act was passed, what some law firms started doing was recommending to their clients that, well, if you're going to sign a subcontract, you should require that the subcontractor waive any protection that they're given under the Contractor and Subcontractor Payment Act. That provision was struck down by a court. That's not enforceable in the Commonwealth. But in terms of the lien law amendments, the legislature addressed that right up front by saying that contractors cannot be required to refrain from filing a notice of furnishing as a condition of entering into a contract to furnish labor or materials. Now, on this point, Our recommendation is going to go further than that, and our recommendation to clients is going to be, instead of just being silent on the issue, you should affirmatively indicate in your subcontracts that both the subcontractors that you're contracting with and any second-tier subcontractors should file a notice of furnishing within 45 days of performing work on the project to ensure that they have lien rights. I think if you affirmatively state that in your subcontract, you will be protecting yourself against the risk that a sub would contend later on, well, even though it's not in the subcontract, they told me I better not file a notice of furnishing. And if they make that allegation and you have it in your subcontract, you're obviously going to prevail on that argument. So that's going to be our recommendation once this directory is created and put into service. Now, interestingly, the legislature really tried to add some teeth to this provision by indicating that if you violate it, you are subject to criminal sanctions, not just a civil penalty. And the subcontractor will not lose its lien rights if it can prove that it did not file a notice of furnishing as a direct result of an owner or agent coercing it, basically, into not filing a notice of furnishing. In addition, the sub is provided with a statutory civil cause of action where they can get actual damages in addition to attorney's fees and court costs. And again, this is just some more teeth to the provision we were just talking about. A contract for a project to which this act applies must contain a notice that expressly warns that a subcontractor's failure to file a notice of furnishing may result in the forfeiture of the right to file a mechanics lien. So it's really an affirmative obligation on behalf of general contractors really to notify subs what the law is. So it's a somewhat unusual provision, but again, you're going to need to start taking a look at your standard subcontracts to make sure that you're conveying this in your standard subcontract. Now, any abuse of the directory, again, is going to subject people to fines, and you can see those provisions right there. A very significant revision to the lien law, as you can tell. Again, if you want to see how this process is going to work once it's implemented, take a look at how Ohio has done things. This is a very similar structure to what has gone on in Ohio. And we will be following this. As I indicated, the directory is there's not even a draft of the directory available at this time, but as soon as that comes out, we will be sure to notify everyone via our blog. I'm sure we'll have an update on this